When we describe active listening, what which is a critical part of a killer cross-examination. It's a critical part. It means losing the notes. It means not having your head down and focused on the podium and the piece of paper in front of you. It means that if the witness throws you a ball that you're not expecting, that you can actually hit it or catch it because you're in the moment and you realize that what the witness is doing, what he's up there doing is he's drowning. And any lifeguard learns, when a person is drowning, they're willing to drown anybody around them. They'll grab onto the lifeguard. They'll grab onto a swimmer nearby. They'll do anything they can to try to use anybody they can as a buoy. And our goal, my goal, the goal of this type of cross-examination, and the goal of this podcast is to help you reach that point where when witnesses are testifying and you're examining them, that they are literally, I mean not literally, but figuratively drowning in court. And we just let them drown. They may tread water for a while in front of the jury, but they end up drowning. And we try to imagine, what is the jury thinking? There are some cross-examinations, for example, where we started towards the end of the day. And the witness is done after 5 minutes of cross-examination. They're done. They're toast. But we are thinking, we want the jury to go home at the end of the day with that witness's awful, destructive, painful, defeatist testimony in their minds. We want them to drive home at the end of the day as they're leaving the courthouse thinking, God, that witness sucked. And that's as good as the prosecutor has. That's their best witness. One of the things that we're doing all along is, as I'm questioning a witness, I'm watching. I'm looking at the way that witness is testifying. We're watching the way the jurors are reacting. And as the jurors sink further and further and further into their seat, as they appear more and more and more appalled by the way that witness is testifying, we may just keep going. We may just keep going until we look and see the jurors almost waving a white flag, like, we got it, we have enough, and then we move on. One of the things that I think that is really important part of killer cross-examination is having some wit, having some humor about you. Look, courtrooms are awful places. I happen to love being in the courtroom. But courtrooms are typically not friendly places. Not many good things other than marriages and adoptions happen in the courtroom. People get divorced in court. People get sued in court. People get prosecuted for crimes in court. Courtrooms are, generally speaking, and courthouses are generally for problem solution and for people to air their grievances. So there's a lot of suffering that goes on in courtrooms. And so there's a general idea that somehow, somewhere along the way, this idea from England, I don't know, where the guys wear like the solicitors and the barristers, they wear like those wigs and they wear like the black, and they powdery faces, and they're very serious and very stoic. And there is a time and place for that, don't get me wrong. But there are moments where humor and wit can deliver some of the most piercing cross-examination moments. And if you're not able to seize on the opportunities to inject some deadly humor, some deadly dry wit into the courtroom, into your cross-examination, then you're depriving yourself and your client of maybe one of the key tools of persuasion. Anybody who's watched me cross-examine knows I react to the judge, I react to the witness, I react to the prosecutor, I react to the jurors. But there are times where there are moments for levity. And we're not going to miss those opportunities, because sometimes those are lethal darts. Cross-examination is not for the weak, and it's not for the timid. It is, every time I get up there to cross-examine somebody, you have to understand that I view it as a battle. You have to have some competitive fire. And you have to be willing to take someone down. I mean, this is This is like a UFC fight where you've got to keep punching that person. You got to bloody him. You got to injure him. And you got to keep going until either they tap out, which in court really never happens unless a witness pleads the fifth on the witness stand, or until you're done. In this way, you're sort of your own referee. You have to make the decision. You have to decide when you're cross-examining the witness. It is no holds barred. You have to decide when enough is enough. It would be great. It would be great in a perfect world as we're cross-examining if jurors were able to hit like a button. Each juror is able to hit. I've seen enough. Juror 6, 10, 12, 2, 8, 1, 3, 4, as they're going on and they're all hitting the button saying they've had enough. And we just have to then we got 2 guys left, and we just need to keep working the witness until those 2 say, yeah, we've seen enough too. The witness is lying. He's not believable. He's not credible. But that's not the way that it works. Jurors don't get to just raise their hand, or a white flag doesn't pop up from behind their chair when they're convinced that there's reasonable doubt or that we've destroyed the witness. So instead, we have to, as a lawyer, you have to have a feel for when enough is enough. But before you cut off that cross-examination, you have to know that you have done everything in your power to reveal that witness to be unreliable and untruthful.